The judgment for the complainant in a religious discrimination case brought before the Equal Opportunity Tribunal is being heralded as a landmark. The case of Giselle Glaud versus Quality Security Bodyguard Services Limited was heard before the tribunal in October 2015. Ms. Glaud claimed she was discriminated upon when in March 2012 she was fired for wearing her hijab after having converted to Islam. The company had claimed that the hijab conflicted with its uniform code. The tribunal, chaired by Rajmanlal Joseph, noted that accommodations were made for other faiths, such as requests by Seventh-day Adventists to have their Sabbath day free of work duties, but that the company was not prepared in any way to make accommodations to Ms. Glaud. The tribunal ruled that Ms. Glaud be compensated to the value of $150,000 with interest at a rate of 6% per annum from the date the complaint was filed. The company also has to repay legal costs to the tune of $22,500. Now, to give further insight into this judgment, in studio with us is Ms. Glaud's attorney, Jason Nathu. Welcome, Mr. Nathu.
Hey, good evening, Samantha.
Now, this is being hailed as a landmark ruling, and I understand it's one of the first decisions made by the relatively new Equal Opportunity Tribunal.
Yes, that is actually the case. The Equal Opportunity Tribunal would have been established after the Equal Opportunity Commission, and what usually happens is that the Commission would refer cases to the tribunal to heard when the Commission would have done an investigation, etc. This case, this judgment today is one of the very early judgments. In fact, I think it's the listed judgment on the tribunal's website.
So what does this mean for cases like these in the future?
Well, it means that there are avenues available for complainants who feel that they have been discriminated against. As you know, the Equal Opportunity Act provides protection against discrimination on many different bases: race, religion, age, and it means now that this avenue is now available. Previously, complainants would have had to rely on the high courts, but as our jurisprudence develops and we have organizations such as this one, it means that redress is now available and that there are more avenues for redress for the person.
So what about the businesses that may have a dress code policy? How is this going to impact on them?
Well, I think what the judgment shows is that if it is that allowing for some sort of religious accommodation to the dress code, businesses just views of the employees, if a uniform code cannot be absolute, it is something that have accommodation for an employee.
Thank you very much, Attorney Jason Nathu there speaking with us as the Equal Opportunity Tribunal rules in favor of a Muslim woman claiming religious discrimination.